Hello everyone, myself Dr. S. Karthik Kumar, Associate Professor, Department of Biotechnology, Kamaraj College of Engineering Technology. Happy to welcome you all. Today I would like to take you to the lecture IP filing process in India from idea to grant. This is going to be the first part of this topic. Let's go to the next. The outline of the presentation is, today you will learn what is patent and why you are supposed to file a patent, and I am going to give some statistics, some infographic where it will give some eye opening statistics. We will discuss about it. Then I will take you to the process of filing patent. This is going to be in the part 1. The next part I will take you to the patent search, some examples how to do public search and the fee related to the patent filing, and I take you to the sample patent filed and granted and the support from the government schemes. Let us see what is patent. Patent is one of the legal rights to the inventor for protecting his innovations. That is the patent. For a limited period, it is supposed to be 20 years, and there are some mandate to be a patent filing. The innovation is supposed to be a novel, and it should involve in the inventive step, and it should be useful for industry application and society relevant. Before going to that, let us see what is the difference between the discovery and invention and innovations. These are the three important terminology related to IPR. The discovery is the term, it is talk about that materials. So, if you bring some new material to the world, it is called as discovery research. It is a very basic fundamental, where in the slides you could see example as the rubber. Rubber is a polymeric material, it is discovered from a tree, where that material property is revealed to the research community, then the property is taken for the different applications. So, the first application, the process it is revealed how it can be used is called as the invention. This is the second level of the research. The material is characterized for its applications for commercialization. In the commercialization aspect, the innovation comes to the picture, where that according to the property, the material can be used for different product formations. So, in this example you could see how the rubber can be used in different applications products. So, this is called innovations. I hope you all can understand clearly. The discovery is about that material research based on its property. The process is refined for the commercialization aspect. That stage is called as invention. Once the commercialization is ready and being a different products it's get out of that material is called as innovations. There are different categories in the IPR, intellectual property rights in India: patent, trademark, copyright and plant breeders right, model designs, geographic index and trade secrets. There are so many categories in the IPR, in which for the related to academics we give more importance to the patent, copyright and designs. For industrial aspects, it is going to be more insights on the trade secret and plant breeders right. In the term of society registration, corporate, the geographical index is come to the picture. So, in this lecture we are going to see more on what is patent, how the process is going to be done for the patent filing process. Okay. First question is, we should know what can be patented. That is the first question. You all know that you can develop a innovations in terms of either product or the process. It can be a product or any device, or it can be a process, or it can be a method, or the composition of the matters. The formulations of any ingredients, anything can also be patented. The main thing is it is supposed to be the new one and involve the inventive step and capable of industrial applications. I give you one example. So, you could see that light and fan in a room for a different purpose. For example, light is a product for illuminating. The fan is the one for circulating the air for the proper ventilations, air circulations. If you merge the two products, it is not a innovations, because two products are involved for different applications, where there is no inventive step is brought there. For example, if you develop a fan into a smart applications, so voice based modulations or image based processing, if you control any fan or any smart devices, no, that is a inventive step is involved. So, what I am saying here is just comparing two different products with the two different applications is not going to be a inventive step. It is supposed to be a new feature to be added into the existing product, then only it be considered as a patentable technology. Okay. Another question is, we should know what cannot be patented, that is most important. So, you cannot take all the invention technology for filing a patents. The very first thing is, in the medical research, the onco mice, the animal models being used in the cancer research for developing a drugs, where that onco mice is genetically modified and it is being tested for various cancer drugs. So, that mice cannot be patented, because coming to the point of computer science, artificial intelligence, data science, where the programs, algorithms cannot be patented as such. You need to integrate with a hardware component, unless otherwise it is not patentable. Then creating a puzzles, formulations, any protocols and languages, that cannot be patentable. Okay. We should know filing a patent, IPRs, what are the benefits you will get out of it. There are so many benefits to the academic community as well as the industry community, where you will get a very good recognition and it's reach the public visibility and government benefits, and a lot of privileges you will get once your innovation is patented. Okay, as I said, we will see some statistics related to the patent filing in India. This data shows that in various years how that a patent, designs, copyright, trademark, number is increasing. You could see that in every year the number of patents filed in 2022 is very higher than the 18-19. Before COVID, the number is very less. After COVID, the number in terms of patent, designs, copyright, all these things, the number is very hugely increased. It shows that there are so many products is coming to the market and it's get filed by the Indian Patent Office. I am happy to say that in the filing rate, Tamil Nadu is standing as the number 1 with the 7,686 filed patent. It is standing number 1 in the category of patent filing, followed by Maharashtra and Uttar Pradesh. Okay, in this slide you could see some eye-opening statistics in India Patent Filing Office. There are so much of patent applications are coming from foreign nations. Look at the statistics here. Other than natural persons, by the foreign applicants, it is very higher than the Indian applicants. In Indian applicants, it is only 6,202, whereas in by the foreign applicant the count is 37,520. It shows that India is going to be a commercial hub, where that other countries is going to come and file their patent and get it marketed, getting more profit. So, India it's that is why making a lot of awareness program to make to create a awareness on that academicians to go for a patent filing. Okay. In the foreign nations, we should know which country is standing first. Look at the statistics. The USA standing number 1, followed by the China. They are submitting more number of applications to Indian Patent Office, with this USA, China and Japan. Okay. This statistics shows you which company is filing more number of applications in the patent office. It's the number 1 is Qualcomm Incorporated Technology, related to communications MNC company. They have submitted around 3,482 applications in last year 22-23 year. And you could see there are so many communications companies are filing a patent in India. As I have told you earlier, India is going to be a commercial hub on the global level. So, all the foreign companies are showing the interest to filing the patent in Indian office. Okay. Next important thing, we should know what is patent office, how the patent applications get evaluated. You should know that there are some examiner called patent examiner and subject wise. In this case, life science, biochemistry, biotechnology, biomedical chemistry, this comes under the life science category, where that number of examiner available in India is shown in the statistics. Look at the statistics very clearly. Only 7 patent examiners are available in the category of biochemistry, 21 in the case of biotechnology. It shows that there are so much of applications coming to the Indian office, but the number of examiner available to evaluate the application is very less. That is why it is taking more time get it granted. So, this is one of the gap we have identified in the patent filing process. Definitely it gets rectified soon. In the case of other field, for example, electrical electronics engineers, where that number of examiner is 163, it has more than sufficient number of examiner to scrutinize the applications. So, that is why in the category of ECE, electronics communications allied field, if the innovations falls under this category, your applications get processed quickly and the grant will get fast. Okay, let us move to the main topic of the lecture today, how to file a patent, how to convert your project into a patent. Okay. I give you a thumb rule. So, before you filing a patent, you should not disclose your invention in any of the academic or research forum, even in a conference presentations or submitting a proposal to various competitions. You should not do that. If you feel that your innovation is worth for filing a patent, you are supposed to register in the patent filing office either in the form of provisional patent or complete specifications. Before start of the experiment, before getting the results and concluding remarks of your innovations, you can go for a provisional patent. If you already started your experiment and you have enough results to concluding your remarks, then you can go for the complete specifications. So, that spot you should keep it in your mind before filing. Even your idea comes first, immediately go and file your patent in the category of provisional patent. Okay. This is the flow chart, it shows you the process how it gets filed. The first initiate step is filing your applications. There are two applications, form 1 and form 2. Form 1 comprise of your basic details. It's asked your name, address and your mobile number, contact address, all these things, basic elements of your the inventors as well as the applicant. I would like to highlight the person who developed the technology is called as inventor, and the person who is going to submit the application for protecting IPR is called as applicant. So, here make sure that are you comes under the category of applicant or inventor. So, ensure that if the applicant only can file the process. So, they submit the form 1 to the patent application office either in the form of online or offline. So, here once the form is submitted, it will be kept for 18 months in a publication stage, where your application will be published in a patent journal and it is open to the public for any review. Any opposition comes, if somebody is claiming that the technology is for them and they are asking it is a claim, no, we need to give a opposition, we have to clarify their oppositions. So, it goes for the request for examiner. So, then the applications move to the next desk, it is called as examination panel, where as I have mentioned in the previous slide, the examiner, patent examiner will go through your applications, they will verify whether the technical part is correct or not, it is new or it is having an inventive step or not. Once they have found any issues related to your invention, they will issue a remarks. It is called as first examiner report, FER. After getting the first examiner report, we need to file a response to the report, that is called filing response. Once the response is satisfied, it go to the granting stage. Then the grant will notify to the public domain, the patent has been granted to the particular applicant. If it has not satisfied the examiner point of view, then it go for the hearing. It go for the hearing point. Then if you fail to justify your remarks, automatically the applications get refused. Sometime after getting the grant also, if any opposition comes, that is also called for the hearing process. So, imagine that once the patent is granted, you will be the owner of the inventions. It is not sure that even any persons can oppose your technology after granting. So, it is called as pre-grant opposition, post-grant opposition. So, in the post-grant opposition, you will be called for the review. If it is not satisfied, it will be refused. If it is satisfied, you will get your patent get granted. So, this is the process, the overall process of patent filing in India. So, with this we close the part 1 session now. Thank you.